You spent your entire life working towards retirement, building a nest egg. You have a pension, you have 401ks. These are valuable. You want to be in a good position for later in life. And then what happens? Divorce happens. So you ask yourself, what is going to happen to my pension? What is going to happen to my 401k or my IRA? The answer to the question of what happens may surprise you because it's not a simple one, it's extremely complicated. One of the biggest misconceptions that people have during a divorce is that if a retirement account or really any asset has just their name on it, it automatically belongs to them. Unfortunately, that's not always the case. And waiting till the end of a divorce to address the retirement issues and retirement assets can create major problems that are expensive to fix later. For the rest of this video, I'm going to explain to you things to look at regarding your retirement assets, things to consider when going into a divorce if you have these assets. Because failing to focus on these items could really detrimentally affect your future. My name's Charlie Shane, and I help people protect their retirement assets through divorce. Many people enter divorce believing that their retirement account is a simple matter. They might assume that their retirement account is theirs and their spouse's is theirs, and everybody walks away with what they built up, and that is the fair way to divide it. But retirement accounts often involve years or decades of contributions, market growth, employer matches, and periods before and during the marriage. This can make things way more complicated than people expect. So most people will take a look at their account balance, the time of their separation, and just kind of negotiate around that number without considering multiple other factors they need to be looking at. But the balance alone doesn't tell the whole story. Questions often arise about when contributions are made, how the account grew over time, and whether certain portions may be treated differently under Washington law. Washington courts are going to look at multiple things when looking at your retirement account, and whose name on the account isn't the only thing that they look at. So it's necessary to do a careful analysis of your retirement accounts and to figure out a strategy that works for you. So some of the things that I will look at is, for example, on a pension, do we want to get the present market value of the pension and use that as a negotiation point? So I usually will get an accountant, they will spit out a number after going through their process, and we can use that number as negotiations rather than divide up your pension when you retire. So that's an option. You also want to consider things like the amount of contributions made during the marriage. Because unlike other properties, say a house, which you bought before the marriage, that remains separate property, the courts will look at the contributions made during the marriage. And so that becomes community property. And then you have how much of a percentage of the gains were made through the marital contributions versus how much of a percentage of the gains were made through the separate property contributions. Also, it's very, very important that if you started contributing to the asset before you were married, that you get documentation of the value of the asset when you were married. Because you could run into problems where they say, well, we don't really know how much was there before, and you spent all these years during the marriage, so we're just going to call it community property because we don't have any evidence of the premarital value. So there's all kinds of traps and pitfalls for the wary or for the unwary that you could run into if you don't know what you're doing in regards to the assets. Another important thing too is that once a determination is made as to how to divide the assets, say a pension, you need to have an attorney who can create what's called a qualified domestic relations order to divide up that pension. And there are very specific requirements that are needed for these orders. And you want to get them done quickly because you don't want to wait until the pension's starting to be divided or the point where the other party retires to do this. You want to get it done right away. Also, you need to think about things like survivorship benefits, which cost more, but they make it so your benefits from the pension don't get cut off if your ex-spouse predeceases you. As you can see, there are so many factors involved. I've only shown you the tip of the iceberg regarding retirement. It's complicated. And this is where having good representation matters. The goal isn't simply dividing the numbers on the statement. The goal is understanding what the account represents, how it fits into the overall property division, and whether the proposed resolution aligns with your long-term financial goals. These are some of the questions you need to consider answering when approaching this type of a situation. How does a retirement account compare to the equity in the home? What other assets are involved? What trade-offs are being considered? What impact could today's decisions have years down the road? These questions often reveal considerations that people hadn't previously thought about. And having that information allows people to make informed decisions instead of relying on assumptions. If you or somebody you know is facing this situation in a divorce, who has retirement assets that they built up, give my office a call. We would love to help you out. Or look on our website and set an appointment. We'll discuss your situation, explain how Washington law applies, and help you better understand your options moving forward.